provision for this, as do the correspondence that has been addressed to Mr. Holden and our other clients.
Unfortunately, I don't think this is time to make speeches. If at all he wants to cross-examine, let him go straight into cross-examination.
Thank you, Chairperson,
Thank you.
we will proceed.
Thank you.
Thank you, Chair. Mr. Vermeulen, we've heard during proceedings thus far that you have many pressing engagements to return to in Simonstown.
Just hold on. Maybe just to get our records straight, can we get your full names?
Sure. My name is Paul Edward Holden. Let me begin again. Thank you, Chair. Mr. Vermeulen, we've heard during proceedings thus far that you have many pressing engagements to return to in Simonstown. As such, I will endeavour to conduct this cross-examination in as short amount of time as possible. I'd like to focus first on the issue of the RFO value system, that's a request for offer value system, which may seem rather technical to the casual observer, but I think is critical to understanding whether the submarine evaluation was conducted according to good procurement practice. Would you agree with that statement? Mr. Vermeulen, during your testimony, you confirmed that you were appointed as the Armscor program manager serving on the integrated project team from May 1996 onwards. Is that correct? And you served in this position for the duration of Project Wills?
That's correct.
As a matter of interest, at what stage did you cease being Armscor project manager for Project Wills?
I have not ceased being program manager for Project Wills. I'm still occupying that post, albeit other posts as well.
Briefly, Mr. Vermeulen, could you recap what your responsibilities were as Armscor program manager for Project Wills?
During the RFO process or throughout the entire acquisition process?
Throughout the entire process.
I think you must try and be specific. That question, if you say during the entire project, he has been in that position for 15 years. Plus minus 15 years. Are you saying to him now, he must tell us what he has been doing from 1996 or 1995 until yesterday? It's too vague a question. Maybe try and be specific, because it tells you that he's still the project manager.
Thank you, Chair. Could we then restrict the answer just to the RFO phase, please?
Certainly. During the RFO process, going back to the value system, I was involved in preparing the value system insofar as the parameters that were to be considered, working with submariner user specialists, with ILS specialists, and the like. So my role in terms of the value system was actually preparing the document, debating in terms of the weighting processes that were contained therein, and the actual parameters that were to be considered at a subsequent stage, i.e. during the evaluation itself. Once the offers were received, my role continued in that I assisted in scoring together with the rest of the integrated project team. And essentially, in terms of the evaluation, it ended with the scoring, the basic scoring of the values obtained from the 4 bidders.
Just to make this entirely clear, thank you, Mr. Vermeulen. As you testified last week, one of your responsibilities as Armscor program manager was to compile the request for final offer document that was distributed in February 1998 to the 5 bidders selected following the completion of the request for information evaluation. Is that correct?
That is correct. That process took place after the RFO, after the value system had been compiled. The RFO that was to be distributed to the bidders was compiled by myself, together with all the attachments from various departments.
Would it be fair to say then that you are familiar with the content of the request for offer document that was distributed to the 5 contenders for Project Wills in February 1998?
Yes, that would be a fair assessment.
Now, to clarify and reiterate points made in your testimony last week, is it correct to say that the offers made by the bidders selected in the RFI phase, were to be evaluated according to the RFO value system?
Yes, as I stated during my testimony, the RFO responses are binding and more formal than that of the RFI. So the RFI relatively is insignificant compared to the RFO.
Mr. Vermeulen, you testified that during the evaluation of bids submitted under the RFO process for Project Wills, you served on the integrated project team focusing on the technical evaluation of the submarines, and that in this role, you would have been very familiar with how the RFO value system was applied to the bids to drive out a result. Would you agree with that?
Yes, in terms of the scoring of the basic results, I was familiar with that, yes.
Just for clarity, could you briefly recap what the function of the RFO value system was?
The RFO value system was required to drive out essentially or to provide inputs that could be used to select a preferred supplier, taking into account the other 3 components as well that were happening in parallel, i.e. the military value system, of which I was involved with, the IP value system, and the financing. So it was a component of that, and it was designed to provide the necessary inputs to SOFCOM so they could make a fair assessment in terms of selection or recommendation of a preferred supplier.
Thank you. Chair and Mr. Vermeulen, can I now refer you to page 99 of the declassified documents bundle as it was described last week? Page 99. Is everybody on that page? To confirm, Mr. Vermeulen, the document starting at this page is the final value system that was used to evaluate the bids submitted as part of the RFO process, correct?
That's correct.
To the following page. Mr. Vermeulen, this page confirms that the value system described in this document was approved and adopted on the 11th and 12th of May 1998. Is that correct?
Yes, that would be correct, Chair.
Could you please name the individual who is responsible for the value system?
Yes. The value system was compiled by the then project engineer, Mr. Gregory de Monk, who was employed as a civilian in the Navy, in the Naval Engineering section. The responsible party was Commander Reed, who was appointed project officer at that time. It was approved by Admiral Howell, Director Naval Acquisition. It was also approved by Rear Admiral Simpson Anderson, Chief of the SA Navy, as well as by Mr. Sheikh, who was Chief of Acquisition.
Thank you. So to be pedantic, this is the value system that was used by you and your fellow members of the integrated project team to evaluate the bids submitted under the RFO process, correct?
Yes, that is correct.
And it was this process that drove out the results you presented on your slides to the Commission last week that showed that the German Submarine Consortium as the lowest scored bidder, correct?
That is correct.
Thank you, Mr. Vermeulen. Can I now refer the Chair and the witness to page 107 of that same bundle? Could you read into the record paragraph 6.5 and 6.6 for me?
6.5 reads, once the offer is received, the various categories are then measured against the SA Navy's requirement by scoring the criteria out of a predetermined score, and then multiplying it by its relevant weighting factor. This process is rolled up until a final percentage is obtained, reflecting in essence the three major portions of the acquisition. This score then serves as a relative measure between the offerers and may be permeated by other factors such as the life cycle cost, acquisition cost, or the cost of ownership.
Thank you, Mr. Vermeulen. Chair, Mr. Vermeulen, can I now ask that you turn to page 118 of the declassified documents bundle of Mr. Vermeulen? Mr. Vermeulen, can you read the title of this document, please?
This document reads Project Will Submarine Evaluation.
Could you explain what purpose this document served in the acquisition process?
Unfortunately, it is difficult for me to do this, in that this document only came to my attention in recent weeks when I prepared for my statement. I hadn't seen this document before. I was under the impression that our basic results had always been directed directly to SOFCOM, but obviously this intermediate step took place, which up until recently I was unfamiliar with.
Mr. Vermeulen, based on your reading of this document, and I suppose my reading as well, I'd like to ask you to clarify something. My reading, and I'd like to see if you agree with it, is that this document was, amongst other things, written to confirm the recommendation that the German Submarine Consortium was the winner of the technical evaluation, and it was this outcome that was forwarded to the Strategic Offers Committee for compilation.
I believe it's clear from this document that that was its intention, yes.
Thank you, Mr. Vermeulen. Chair, Mr. Vermeulen, can I now ask that you turn to page 124 of the declassified document bundle? Mr. Vermeulen, could you read paragraph 15 appearing on that page, and if you wouldn't mind including the formula?
Paragraph 15 reads, in determining the Military Performance Index, MPI, of the various options, the ratio of the performance, logistic, and engineering management values and the associated costs were calculated in accordance with the formula below. The formula reads, MPI, Military Performance Index, is equal to the factor X times performance score divided by the cost, plus factor X logistics score divided by the cost, plus factor X engineering management score divided by the cost.
Thank you, Mr. Vermeulen. This is obviously an absolutely crucial formula. If I may attempt to summarize the position, this was the formula that was used to drive out the final results for the Military Performance Index. The scores awarded as the Military Performance Index were what were used to determine the best bidder in the technical evaluation and in the scoring adjudicated by the Strategic Offers Committee. It was the application of this formula to performance results, which you were part of evaluating, that drove out the scores that formed the Military Performance Index. And it was the application of this formula that saw the German Submarine Consortium move from last place in the performance results to first place in the Military Performance Index. In other words, it was the application of this formula that allowed the bidder, the German Submarine Consortium...
Just hold on, sir. What are you reading from?
Sorry, Chair, I didn't hear the question.
What are you reading? Well, where are you reading from? Because I'm trying to follow. I can't see the statement that you're reading.
Sorry, Chair, I'm trying to summarize what we've covered to date and ask if he agrees with what I've stated in the statement.
Are you making a proposition to him?
That's correct, Chair.
Maybe if you can just be slow when you read it, because I end up also missing some of the things that you're saying. Thank you.
Fair enough, Chair. I was told during primary school that I was a terrible mumbler, so if that happens again, I apologize. Should I start from the beginning of that line of questioning? Mr. Vermeulen, this was an absolutely crucial formula. Do you agree with that statement?
It's difficult for me to agree with that in entirety. I can only make an assumption that it was, bearing in mind I wasn't privy to the exact process that took place. This report was forwarded to SOFCOM, no doubt, and I'm not sure exactly if SOFCOM took this at face value in its entirety, so it's difficult for me to agree with you 100% in terms of your conclusion.
Thank you, Mr. Vermeulen. Based on your reading of the document, it was the formula that you've just read that was used to drive out the final results for the Military Performance Index. Is that correct?
It certainly would appear so.
And it was the scores awarded as the Military Performance Index that were used to determine the best bidder in the technical evaluation and in the scoring adjudicated by the Strategic Office Committee, bearing in mind what you've just said?
Yes, it was.
It was the application of this formula to performance results, which you were part of evaluating, that drove out the scores that formed the Military Performance Index. Is that correct?
Again, I can only assume that to be the case. I didn't have the background which the author had in drawing up this evaluation. For instance, in that formula, I can't say exactly how those individual costs were ascertained. We didn't have that sort of breakdown available to us at that level. For instance, the engineering management score, I've no idea how he actually arrives at that specific cost, bearing in mind the guidelines provided by SOFCOM, which Mr. Davy Christel provided some days ago, in which he stated that the total basic score should be divided by the total basic cost, as I've testified in previous days. It obviously would appear from reading this document that that was not applied.
You've preempted my questioning somewhat. I think you know where I'm going with this. If I can just return to the questioning, would you agree that it was the application of the formula that you just read from earlier that allowed the bidder, the German Submarine Consortium, with the lowest scores in the technical evaluation conducted by you and the Integrator Project team, to emerge as the winner of the Military Performance Index evaluation?
Assuming that SOFCOM took this at face value, then I must assume that. But it's an assumption on my part. I didn't know the mechanisms exactly which applied to SOFCOM and the precedence, the significance they provided to this document. I can't say specifically, but I can only assume that.
Thank you, Mr. Vermeulen. I appreciate it. It's difficult to speak to a document that you weren't the author of. The Commission may be wondering where I'm going with this, so I'm going to try and clarify this now. Mr. Vermeulen, does this formula that we've just quoted from appear anywhere in the RFO value system as approved on the 11th and 12th of May 1998?
No, it does not.
This is quite an important point. I'd like to repeat it. While a formula of this type may have been anticipated by paragraph 6.6 of the value system, this particular formula did not appear at any stage in the RFO value system document. Is that correct?
Yes, that is correct.
Mr. Vermeulen, during your testimony last week, you appeared somewhat surprised that this formula was used to drive out the Military Performance Index scores. It appeared, to my view at least, that you only became aware of the application of this formula when you were allowed to view the submarine evaluation report compiled by Captain Reed and Admiral Howell during the preparation of your testimony. Is this correct?
Yes, that is correct.
Without putting words in your mouth, I would imagine that you would not have been so surprised if this formula appeared in the RFO value system with which you are very familiar, correct?
It's difficult. I think it would have been practically difficult for it to appear in the RFO value system because I'm not sure if the formulation of the SOFCOM had been finalized at that stage. So I think the author in the value system would have had some hindsight, had to have had some hindsight knowledge to include that formula at that early stage in the value system. I think that the actual level 2 or second tier SOFCOM only really took shape subsequent to the RFO value system, but I might be incorrect.
I'm going to ask a slightly difficult question now, I hope you don't mind. And it may be a slightly unfair question, as you didn't actually compile this document. But here I'm just trying to get your opinion. If this formula did not appear in the RFO value system document...
I'm sorry. I say you want to get his opinion.
That's correct.
Opinion.
Yes.
Is that opinion going to be of any value to us? Particularly if he was not part of if he is not the author of the document. Shouldn't you perhaps ask him about what he has done and what he knows? I'm sure you'll agree with me that his opinion is not going to be of much value to us, because we have the documents in front of us. We can read it and from there form our own or make our own determinations. If you can try and avoid asking questions where he must speculate.
Fair enough, Chair.
Ask him about what he knows, what he has done. Thank you.
If I may respond to that, Chair, I feel that his opinion would actually be very valuable. It doesn't seem that you agree with that. I base this on his CV, his long experience within the procurement process, a very intimate knowledge of how the RFO process operated. And while he may not have authored this document, I'm almost 100% certain that he understands its contents and can comment on them. Would you like to respond to that?
I can't respond to you. If you told me you want to continue in that line of question, ask me whether I do agree or not. But then I don't think that I can comment or respond on what you say to me. I was just trying to say to you that just be careful not to ask him to speculate. He told us exactly where he was involved and where he was not involved. So try and avoid asking questions where you say he must speculate. Let him not speculate. Ask him to tell us what he knows.
Thank you, Chair. I do apologize. This is the first cross-examination I've ever conducted. So if I don't know the exact rules, I hope you will accept my apology. I suppose the key question I want to ask you here is, if the RFO value system document, if the formula did not appear in the RFO value system document and did not form part of Armscor's usual procedures, do you have any idea how this formula was generated?
I honestly don't know how the formula was generated.
I'm going to ask you what might be a speculative question. I hope not. Do you have any knowledge of who would have had the authority to approve this generated formula?
I really don't.
Okay, thank you, Mr. Vermeulen. I'm now going to ask you what Advocate Labala referred to as an evaluative question during your testimony. Do you think applying such a crucial formula to drive out the results without them appearing in the RFO value system and in variance with Armscor's usual approach constitutes good procurement practice?
I find it difficult to comment on that, Chair.
Okay, thank you, Mr. Vermeulen. I think you've already indicated this earlier, Chair, but ideally the people that I feel who need to answer these questions are the authors and moderators of this document, namely Commander Reid and Admiral Howell. And if I may be so bold, based on this line of questioning and Mr. Vermeulen's answers, I would strongly suggest the Commission hears from these two individuals. The second issue that I'd like us to focus on is that of the integrated logistics support element of the submarine evaluation, and in particular, how the German submarine consortium emerged as the winner of this evaluation by the time the results were handed to SOFCOM for compilation on the 1st and 2nd of June 1998. This is where I will intend to try and put the critics' version of events to you, Mr. Vermeulen, and do so with more vigor than that employed by Advocate Labala when he raised these matters with you. I'll begin to recap some key facts that we have already recovered. I hope you don't mind this. I do this mainly to ensure clarity in this line of questioning. Mr. Vermeulen, to confirm, you served on the integrated project management team during the evaluation of RFO proposals under Project Wills. Is that correct?
Yes, I did.
In this capacity, you were one of a team of individuals who were tasked with scoring the offers from bidders, who were selected to respond to the request for offers issued in February 1998, in particular the technical evaluation. Is that correct?
Yes, that is correct.
As has been canvassed before, the three elements of the technical evaluation that constituted the final score were the RFO response element, the integrated logistics support element, and the submarine product performance element, correct?
Yes, those were the three overarching categories.
In generating a final score in the technical evaluation, the integrated logistics support element was given a weighting of 67.51%, correct?
That's correct.
This would suggest that the integrated logistics support element was considered a particularly important discriminating criterion in the technical evaluation, correct?
Yes, it was.
Mr. Vermeulen, could you once more explain how the weighting system was devised and how it impacted on the final product performance score?
Yes, the weighting system, it was a bottom-up process. We did a pairing analysis. We would take each parameter and weigh them off against the other parameters. And in so doing, it rolls up to a final score. It's basically a forced decision-making process. And you'll notice from the slides that these are put into the various of the three categories that were mentioned. So basically, when you do the evaluation, those factors come into account because you'll take the parameter itself out of in the case of the ILS, it was 1 to 10, where 5 was the minimum requirement. That particular score would then be divided by 10 because that was the maximum score. It would be multiplied by its specific weight, relative weighting. It would then be multiplied by the weighting of that category, i.e. 67.5%. And that would drive out that particular value then for that parameter under consideration.
Thank you, Mr. Vermeulen. That was an incredibly clear summary. Chair and Mr. Vermeulen, I refer to page 123 of the classified documents bundle. Mr. Vermeulen, just to clarify, this is the submarine evaluation report compiled by Captain Reed and Admiral Howell, as confirmed by page 118 and 119 of the self-same bundle, correct?
Yes, it is.
Mr. Vermeulen, could you please read the total normalized results as appears in the table just under paragraph 10 of page 123, indicating which supplier received which score?
The results of the evaluation of the individual components of the proposals are indicated in the table below. Serial 1, the French Scorpion. For the technical evaluation, 84.8%. Logistic evaluation, 57.7%. Engineering management, 45.9%, giving a total normalized value of 85.67. Serial 2, the German 209, 1400 mod submarine, 87.1% for technical evaluation. 48.95% for logistic evaluation, 71.25% for engineering management, total normalized 80.6%. The Italians, Fincantieri, the S-1600 submarine, 89.4% for the technical evaluation, 71.14% for logistic evaluation, 54.43% for engineering management, total normalized score 100. The Swedish Kockums T192, 88.6% for the technical evaluation, 50.6% for logistic evaluation, 49.84% for engineering management, Total normalized 80.86.
Thank you, Mr. Vermeulen. To clarify, these results confirm that the result of the integrated project team's technical evaluation, according to these results, the German submarine consortium was placed last of the 4 bidders considered, correct?
Yes, as reflected in this table, correct.
To confirm, these scores correspond to the slides you presented last week, correct?
Yes, they did.
Do you notice any material deviation in the scores between this table and what the integrated project team provided as the results of the technical evaluation?
No, this should be in line with the basic scores, the calculations that we would have done, should we have been asked to do those. Bearing in mind, if I could just refresh you, that the role of the IPT specifically was to do the basic scoring. Under normal circumstances, as I explained, we would then have brought price into account, the total contract price.
Thank you for that clarification. Could you now refer to page 124 of the classified documents bundle, specifically paragraph 16 and the table presented? I would like to, but I'm waiting for the chair to nod. Okay.
Paragraph 16 reads as follows. The results of this calculation are summarized in the table below. Serial 1, Germany, the 209 mod 1400, performance ratio 100, logistic ratio 100, engineering management ratio 100, and military performance 100. Serial 2, Sweden, type the T192, performance ratio 79.23, logistic ratio 92.37, engineering management ratio 65.25, military performance 90.93. Italy, the S1600 submarine, 93.26 for performance ratio, 82.48 for logistics ratio, 86.67 for engineering management ratio, military performance 83.13. France, the Scorpion submarine, performance ratio 86.66, logistic ratio 65.29, engineering management ratio 68.82, overall military performance 66.43.
Thank you, Mr. Vermeulen. To clarify, these scores indicate that the German submarine consortium received the highest score in the military evaluation, for its military performance score, despite receiving the lowest score in the technical evaluation conducted by the integrated project team. Is that correct?
That is correct.
I'm afraid I'm going to have to ask you one more question about SOFCOM. If you don't know the answer, then I obviously understand that too. The military performance index formed 1/3 of the final evaluation score as calculated by the Strategic Office Committee, the others being NIP and DIP and financing. Is that correct?
Yes, that is correct.
This suggests that the military performance score was a key score in discriminating which bidder would be selected as the preferred supplier. Is that correct?
It is correct.
Now, as we have addressed already, the military performance score was calculated using the formula contained in paragraph 15. Is that correct?
Yes, it would appear so, assuming that SOFCOM accepted this at the results of this report at face value.
Could you please, in layman's terms, explain how the performance score was converted into a military performance score by means of this formula?
Unfortunately, I can't, as I was not involved with this process. I don't have the background into those individual costs, so I would be trying to delve into the author's mind here, and I think that could be dangerous.
Chair, Commissioner Musi, with your leave, could I note an objection? Mr. Vermeulen has been at pains to point out that he's not the author of this document. it's extremely unfair to allow cross-examination to proceed, really dealing with the detail of this document, which Mr. Vermeulen has no personal knowledge of. It's really getting anyone in this room to comment on a document that they were not the author of. His views on this document and how it came into being and what its content is and what the import of the content is totally irrelevant. It doesn't assist the Commission at all. And it's unfair, actually, on Mr. Vermeulen. So I must object to further questions. I've been indulgent, but I think one must draw a line in the sand now, with your leave, Chair and Commissioner Musi.
Mr. Holden, do you want to respond to that?
Chair, as far as I can recall, Mr. Vermeulen addressed these matters when evidence was led. He addressed this document. I'm merely cross-examining him on the evidence that was led while he was giving his testimony.
Can you refer me to the relevant portions of the record where he says that he dealt with these issues? Because the objection is simple. Mr. Vermeulen was not the author of this document. We are asking him to comment about what other people did. We are asking about what took place in meetings when he was not present. His views will not be of much value to the Commission. That seems to be the basis of the objection. Do you want to respond to that?
Chair, I think I already have responded to that previously. I understand that he's not the author of this document. But I do think that as a person who is steeped in this field, somebody who engaged in the process and is still actually engaged in Project Wills, that he can understand the content of the document, which is actually, I think, pretty straightforward, and that he can testify it with a degree of knowledge that other people may not have because of his experience in that position.
But then of what value is that going to be to the Commission? He said to me that he was not part of that team which drew this document. He's not the author of the document. His answers of what value are they going to be to the Commission?
Chair, I think I've discussed this before, but I do think they're of value to the Commission, again, based on his previous experience and his very detailed knowledge of how the procurement system worked. I would argue that his opinion carries quite a lot of weight, and if I may be so humble as to suggest the Commission should afford it a degree of weight because he's so familiar with the subject.
Advocate Solomon, do you want to respond to that?
Chair, only to reinforce the point that it's clear Mr. Vermeulen does have deep knowledge in regard to the evaluation results. He's indicated that he was involved in the technical evaluation. He was the program manager. He has testified in regard to the performance results that we found at page 123, paragraph 10, that those accorded with the work that he had done, and that's really where his involvement ceased. When it comes to the tables on page 124, in paragraph 13 and 16, he's indicated that he has no personal knowledge of this, and it's really just valueless to continue to ask him and to read out aspects of this document of which he has no knowledge. We understand that Rear Admiral Howell, who is one of the authors of this document, is going to give evidence. I think Mr. Holden can ask those questions of Admiral Howell far more fruitfully than to continue to try and elicit responses from Mr. Vermeulen, which are really just based on supposition and conjecture. He said it as much. It's just supposition and conjecture. It doesn't advance the inquiry which this Commission is engaged in at all. And we persist with our objection.
Mr. Holden, unfortunately, I'm not going to allow you to continue with this line of cross-examination. I don't think that, the answers that Mr. Vermeulen is going to give, will be of any value to the Commission, particularly in the light of the fact that the authors of this document are going to testify.
Chair, I'm afraid I don't understand how the procedures work when I respond to your ruling. I was hoping to make one more point, if that's possible.
Okay, let me hear what you want to say.
Well, first of all, Mr. Vermeulen testified that he's been part of Project Wills since it was initiated. If you recall from his testimony before the Commission last week, he mentioned that he was part of the team, I think it was part of the IONT team, that was involved in negotiating the final terms of the contract for the submarine. In that position, he would have negotiated the final baseline, contract baseline, for the provision of the integrated logistics system. And I would argue that there are some claims in this document put forward regarding, written by Admiral Howell, that he could independently verify, as he was both part of the request for offer process and was also negotiating this process afterwards.
Unfortunately, I do not agree with your views on that point, and I'm not going to allow you to further cross-examine Mr. Vermeulen on this document. Because if you can recall, last week in his evidence, Mr. Vermeulen clearly stated that some of the parties or their preferred bidders was very weak as far as certain areas are concerned, and they went out of their way to try and make sure that there is an improvement in those areas when it comes to contracts. Now, because he said that, you can't want to keep on cross-examining him about issues that happened at a meeting where he was not present, and then two, on a document which he was not present when it was drafted, nor is he the author thereof, particularly if you have been told that the authors of this document will come and testify. So I'm not going to allow any further cross-examination of Mr. Vermeulen based on this document.
Chair, I'm sorry to stick on this point. Would you mind if I was to make one more averment? To do so, Chair, I'm going to have to ask you to turn to page 125 of the evidence bundle, or the declassified documents bundle. Page 125 of the declassified documents bundle. Paragraph 20 is an absolutely fundamental paragraph to understanding the entire way the score was generated. If I may read from the section I think is appropriate to raise at this point. This was in reference to the Germany 209 Type 1400 MOD submarine. It says, the logistics support package is comprehensive, but a large amount of deliverables are offered as options, and this is the key point, as options, and were not costed into the proposal. The log risk is determined as low, but because many options were not considered additional funds should be allocated. Now, I would submit that in this document, what Admiral Howell and Commander Reed are saying is that there wasn't a finalized offer of elements that would form the integrated logistics support system, and that in fact the options upon which the options that would be selected from the German submarine consortium were to be done during the negotiation phase. And as we know, Mr. Vermeulen is a member of the negotiation phase, drawing up the contract baseline. So in that position, he would be able to confirm to me, and this is an absolutely crucial point for the Commission to understand, I think, whether he was ever of the opinion that what was offered by the German submarine consortium consisted only of a series of non-binding options, or whether they actually formed a firm commitment.
A firm commitment on which issue?
It would have been a firm contractual commitment. As we understand, the RFO process was a binding process. A firm commitment as to the exact form, function, content, and price of the integrated logistics segment.
Mr. Vermeulen, are you in a position to answer that question?
Yes, I am, Chair. Chair, in response, I must agree with that observation. At the conclusion of the evaluation, and it's well known that the GSC offered a poor log package, and hence they were penalized in the score as a result of that. When the German Submarine Consortium was nominated as the preferred supplier, I knew we had our work cut out for us, because as you quite rightly say, a number of the elements of the ILS were offered as costed options. We would have to negotiate those into the contract, and at that stage I didn't know the level of success I would have in hindsight. Fortunately, we did manage to negotiate, as I've stated, we managed to negotiate a number of key ILS elements into the contract during the negotiation phase, as you correctly observe. And those included those items that I mentioned previously. So at this stage, yes, the log would certainly from my side have been seen as a risk with the GSC. I didn't know how successful my negotiations would pan out.
Thank you, Mr. Vermeulen. Just as I'm afraid I don't have this figure in front of me, and I've always wanted to know this figure, but you mentioned in your discussion of the contract baseline that there was a ceiling placed by Cabinet on the total cost of the submarine acquisition. Are you aware of whether that ceiling cost was applied to the total acquisition cost, or was it applied to individual elements within the submarine contract?
To the best of my knowledge, that ceiling price would have addressed the full scope of supply and not individual elements.
Okay, I'm just a little bit confused on this point, because you testified last week that you negotiated for certain additional elements to be added into the integrated logistics system, but you did so without increasing the price. That would suggest that there was a price that was set at some stage which you didn't pass. Is that correct?
Yes, if I could try and clarify that. Cabinet approved a certain amount for the submarine contract. What I endeavored to do was increase the scope of supply within the framework of that price approved by Cabinet. I couldn't exceed that price, and I didn't attempt to. At the same time, I didn't attempt to decrease that price. I worked within the framework of that price, and during the negotiation phase, we managed to get further an extension of the ILS package within the scope of supply. In other words, the costed options for the platform simulator and the Combat Information Center simulator, we managed to include as part of the scope of supply. The fifth scale model was never part of the scope of supply. We included that. And very importantly with ILS was the ceiling amount for spares. Now that ceiling amount, I think, was originally in the order of $11 million US, 11, 12, I can't remember exactly. We managed to increase that. The eventual contract price was in euros. Within the amount, that framework price approved by Cabinet, we managed to increase that to 26.1 million euros. So that was all within the financial ceiling approved by Cabinet.
I'm not aware of how the budgeting was being done for the submarine process at this stage. Was there, I don't know how to phrase this, but was there a line item for the integrated logistics support element that indicates what the total amount was that was going to cost the state?
No, and this was one of the difficulties. You would find in the price breakdown that certain ILS elements were included with the submarine. It was very difficult to extract the ILS elements per se as a separate line item. At that stage, at the RFO stage, obviously during the negotiation phase, we did that extraction in detail.
Okay, I think we're working potentially across purposes here. During the negotiation phase, when the contract baseline was finalized, was there a line item that said integrated logistics support element?
Yes, at that stage we had broken down, we had a very clear impression of the costs for the ILS elements. For instance, training, spare parts, as I've just said, the CIC simulators, although they were costed options, we for contract contractual milestone payments purposes, we had to have prices for those. So that was part of the CBL requirement. We broke down the price to that level of detail, where we knew exactly what the ILS elements would cost.
Thank you. The reason I'm asking this is I think that it could be potentially very useful for the Commission to know this information if they do call Admiral Howell at some future stage. Do you offhand, I know this might be a difficult question because it was quite a long time ago, remember what the final cost was? If you don't remember it offhand, it would be useful if you could, I don't know exactly how this process works, Chair, but if we could request a document to confirm what that final price was.
Just hold on, I'm sorry. If you don't mind, when you speak, can you look into the mic, because we're battling to hear you. And I say it's because when you speak, you're facing that side and the mic is on the side.
Would you like me to repeat that statement? If I can just try get this back. I think this is quite an important point potentially for the Commission to grasp, and I think it'll be a very interesting point if Admiral Howell or Commander Reid appear before the Commission at some stage. I asked Mr. Vermeulen whether he was aware in the final contract price that was signed with the German Submarine Consortium, there was an indication of the total final cost of the integrated logistics support element. The reason I asked that is I would imagine that let me put myself into the future. If Admiral Howell was here in the future and I was asking him questions, I would want to try and examine whether the way he arrived at the cost for the integrated logistics segment in his evaluation was fairly done. And I would argue that one way you could do that is to see how close that estimation approximated the actual final cost.
Yeah, I agree with you. You can argue that at a later stage if Mr. Howell or Commander Howell does testify. Can you put the question to the witnesses in front of us?
Mr. Vermeulen, are you aware of the final cost for the integrated logistics support element in the final contract? Or if you aren't aware of it now, is there a document perhaps you could refer us to?
Yes, I don't have the figure available right now, but certainly there is a document. If you recall, I mentioned that I negotiated a supply terms agreement. Supply terms agreement consists of in the order of 20 annexures. Annexure C in the supply terms agreement is the price breakdown, and that describes at a very high level. Remember, there was also a technical specification. The technical specification, which I'm not sure the annexure number. There's a technical specification which outlines in detail every ILS element. And then the costing is in Annexure C, which is a price breakdown. But, okay, so that information is available, and it formed part of the contract baseline. You must just bear in mind again, when the RFO, when this formula was drawn up in this report, that information couldn't have been available. Bearing in mind that a lot of the items that eventually appear in the price breakdown in the contract were negotiated after the event. If you follow what I mean. In other words, at the time of drawing up this RFO evaluation report, the final scope of supply for integrated logistics support was unknown. We had to go through a negotiation phase, which drilled out those details, if you follow my reasoning. But yes, that information is available. There is a price breakdown, and there's a technical specification which describes in detail the ILS requirements.
Chair, again, I'm a little bit unfamiliar with how the procedure works here, but I'd imagine that document would be of great interest both to the Commission and to myself. I don't know if there's a way I can apply to view that document at a later stage, not right now. I don't want to hold up the proceedings of the Commission.
Let's first finish with the cross-examination. You're still busy cross-examining this witness. Let's go through that process and finish with the witness. If you told at some later stage you want other documents, then we can see what we can do at that stage.
Thank you, Chair. I'm afraid my cross-examination has been thrown into a bit of disarray by the ruling that I cannot ask Mr. Vermeulen to comment on this document, but I'll try my best. Okay. Mr. Vermeulen, I've already read into the record. Sorry, I'm afraid that I actually haven't read that into the record just yet. Okay, this is a question that I'm struggling slightly with. During the evaluation of the integrated logistics support segment by the integrated project team, of which you were a part, were you ever made aware by any person or by the documents presented to you that what the German submarine consortium was offering in terms of integrated logistics support was a set of options rather than a binding commitment?
Yes, I was. In their response, they clearly mentioned which were options and which were included in the price. For instance, the simulators at that stage were not included in the price. They also had an option for a second-hand submarine. So they had to indicate exactly what was an option and which was a firm price offer.
So if I'm understanding you correctly, if they were options, were you forced as a member of the integrated project team or any other member forced to try and discriminate between the options to decide which ones you would like to have in the submarine? Or did you take all of the options that were presented as a given and include them in the integrated logistics segment for their score?
No, you can't do that because you don't know the success you're going to achieve. You don't have a crystal ball that tells you exactly what the scope of supply will be. The options, and depending on the amount Cabinet improves, you'd obviously try and negotiate those in. But at the time of the RFO evaluation, you can only take the firm prices. You can only consider those and not the options, because the other suppliers would have also offered options. So you have to take the prices that are offered for the equipment themselves and not the options. So the price breakdown would typically include the submarines. It would include a portion of logistic support. In other words, they offered, as I said, in the order of 11-12 million US dollars. Now, that was a firm offer. That you could take into account. But you can't consider options and assume that you're going to get those options included in the scope of supply during the negotiation phase.
And then just to clarify, because I think maybe I didn't frame my question as clearly as I would have liked. When the integrated project team was evaluating the German submarine consortium's RFO response, were any element within the integrated logistics segment indicated as an option and not a firm commitment?
Yes, there were elements that were offered as options, and they were clearly stated that they were costed options.
Okay, so if you can help me with this. When you drove out the score for the technical evaluation, I'm talking about the basic scores here, and I appreciate this was quite a long time ago. Do you recall whether there was a decision made to treat the options that were given by the German submarine consortium as an element that could be included in generating their final evaluation score?
No, you cannot use the options because you can't be guaranteed that those will eventually merge into the scope of supply. So the evaluation would have taken only those items where there was a fixed price for those.
Okay, I've almost finished with this line of questioning. I'd like you to clarify something. You made a comment in your witness statement that the RFO was binding and was a final offer, and that on that basis that SOFCOM or whatever contracting authority would be able to proceed with negotiations with the selected supplier. What doesn't make sense to me personally is how you can have a final binding offer that includes options that may be selected in future.
No, it's a quite normal process. You'd have a binding offer, and let us assume that we decided to include those options and purchase them at the prices. They do price those options, and you can hold them to that price. Let's assume the platform simulator had a price allocated, which it no doubt did have. You could decide if it was affordable that we would purchase those as well. So it was still, even though they're options, they're still binding. It's like purchasing a motor car. There are a number of options that are also priced, and you can, at your discretion, decide to include those options, and the prices for those options are firm.
Thanks. That actually helps me a great deal. Just bear in mind I try to phrase this question correctly. So if I understand correctly, the options that were presented to you as a member of the integrated project team, the offers offered by the German Submarine Consortium, they were costed, is that correct?
Yes, the options were costed.
And I suppose here we come to what I'll consider, what I've just newly thought of as perhaps the crux of the matter, is that if you look at page 125 of the declassified evidence bundle, I've already read from the section before. It's paragraph 20, and this is in reference to the German 209 Type 1 400 MOD. There's this one particularly curious sentence, which I think you are actually contradicting in your testimony, and I'd like to get your sense of this. It says here, the logistics support package is comprehensive, but a large amount of deliverables are offered as
I'm sorry, from which line are you reading? Because it's a long paragraph.
Apologies, Chair. It appears halfway through the paragraph. It is line 6 of the paragraph. It says here, the logistics support package is comprehensive, but a large amount of deliverables are offered as options and were not costed into the proposal. The log risk is determined as low, but because many options were not costed, additional funds should be allocated. Now, you seem to suggest that actually at that point in time, at least the integrated project team was aware of the costing of those elements.
Yes, to the best of my knowledge, the price breakdown included those costs.
So if I'm to extract the number of the issue here, are you suggesting, based on your own experience as part of that evaluation team, that this document is actually not correct in stating what it does and saying that there are non-costed options?
Not necessarily. I know, for instance, as I mentioned earlier on, there were certain logistic support elements included with the price of the submarine. So you didn't have an isolated cost for those items at the time the offers arrived. But but those items were not necessarily options. They were included as part of the submarine price. So you had to separate those items. For instance, the submarine price included onboard spares. So we didn't know at that stage exactly what those onboard spares amounted to. And there may have been certain options. For instance, the fifth scale model wasn't actually an option, and I'll tell you why it wasn't an option. The Germans had no intention of parting with their fifth scale model. We negotiated that in eventually. We convinced them that they didn't require it once our Type 209s had been built. So they were never options up front. So I don't think you can rule out as being untrue what this author is saying in the statement. You have to understand the background to it, which I'm not necessarily fully cognizant of.
With your leave, Chair and Commissioner Musi, could I just come in here? I'm not sure that that question is fairly put to the witness, because I don't read it the same way as Mr. Holden. I think there's at least an alternate way of reading that sentence. And that should, in fairness, be put to Mr. Vermeulen, because what it seems to say is that the logistic support package is comprehensive, but a large amount of deliverables are offered as options and were not costed into the proposal. It doesn't mean that the option had not been costed, but they weren't taken into account in the proposal. And I see you nodding, Chair, and I think you understand what I'm saying. So I think that should be pointed out to Mr. Vermeulen, that there is another way to read this.
You know, but besides that, it goes back to the problem that I stated earlier on. We are asking Mr. Vermeulen about a document drawn by other people. And you are asking him now to give an opinion on the construction of the sentence. You put to him a question, and he gave you an answer. After getting an answer, you go back to a document drawn by somebody else. You say, but then my reading of this document is A, B, C, and D. Can you please comment? I think that is an unfair question. He's not the author of this document. But besides that, as Advocate Solomon says, that sentence is open to two interpretations. And you cannot say that your interpretation is correct and ask Mr. Vermeulen to comment on your interpretation of a document which was drawn by somebody else. I think that is an unfair question. He gave you an answer of how he understood those options. You can weigh the person, the author of this document, if he comes, then you can put to him that type of questions.
Thank you,
Thank
Chair.
you.
Thank you. I must apologize that I'm not a legal expert. I'm not used to the idea that what I think is a relatively explicit sentence would have multiple interpretations, but I'm going to leave that for the moment. Chair, I'm going to move on to another line of questioning, and I was wondering if it would be possible to adjourn for a short break, to prepare to do so.
I'm sorry, I'm struggling to hear you.
I noticed that it's now, 20 to 12, and I was wondering whether it would be possible, before I start the next line of questioning, I don't want it to be broken up by the tea break, if we could take the tea break now?
I think maybe let's take a tea break up to 12 o'clock. Man.
Thank you very much.
Thank you.
Liz? All rise.
Can the witness confirm that he's still under oath?
Thank you, Chair, and thank you, Mr. Vermeulen. The third major issue I'd like to question you on flows from Mr. Vermeulen's witness statement. Chair and Mr. Vermeulen, I refer to Mr. Vermeulen's witness statement, in particular page 19, paragraph 6.1. This is page 19 of the Vermeulen statement bundle, as was referred to during the reading of evidence last week.
Thank you. We've got that.
Mr. Vermeulen, would you please read paragraph 6.1?
Para 6.1 reads as follows. From a military value perspective, the Type 209 submarines were the most cost-effective of the 3 submarines product systems on offer.
Mr. Vermeulen, do you stand by this statement, or would you like to amend it at all?
I stand by the statement in this context, and I realize it may be misleading. I perhaps should not have used the term military value because that has connotations within SOFCOM. What I'm referring to here is value for money specifically. As I explained in the previous days on when taking the stand, how we would normally do a process like this, assuming we didn't have SOFCOM and an RP index and a financing index, we would evaluate the offers at hand, and we would select, there were 2 key factors that were taken into account. The one was that they met the Navy's requirement, the functional specification, and then we would immediately look at price. And we would say, right, which is the less expensive of these options? And as you know, the GSC did come in cheaper. And that would have been it. I would have made a recommendation then directly to my board in the form of a submission, recommending that we enter into negotiations with the GSC. In those negotiations, I would have outlined the risks, and there were risks. We had a risk with respect to logistics, and I would have outlined a strategy as how I could get about overcoming those risks. Remember, I would also have had to approach my board of directors a second time. Having concluded the negotiation phase, I would then have had to put in a submission for the placement of a contract. So I made this statement and I stand by it. It's purely in terms of best value for money. We could acquire a product that met the Navy's requirement at the cheapest price. So that's a context I'd like to request that you read that statement in.
Thank you, Mr. Vermeulen. I think that is actually the context in which I read it. As far as I understand, there were 4 product systems on offer. Is that not correct?
That is correct.
I just noted that in your statement you said the most cost-effective of the 3 submarine product systems.
Yes, what I meant there was the 3 submarines. You're quite correct. There were 4 product systems on offer. Thank you for that.
What were the 4 submarine product systems on offer?
Okay, the four product systems were as follows. The GSC Type 209 Mod 1400. That was the product system, the one. The second was the S1600 Scorpion. It was a new submarine on offer from DCNI of France. There was a Type 209, a Type 192 submarine on offer from Celsius Cockham's. It was a derivative of the Gotland-class submarine. Which one is outstanding? And then there's the Sauro-class submarine, the Italian Fincantieri submarine, which was offered, which is a derivative of the Italian submarine, the Sauro-class, the S-1600 submarine.
During the leading of your evidence, you provided, I think, in addition to what you've just said, an explanation of why you made this assertion in your witness statement. Chair, Mr. Vermeulen, can I ask that you refer to pages 2,484 and 2,485 of the transcript of the public hearings as posted on the Commission's website? Page 2,484 and 2,485. Chair, I notice that the witness does not have the pages I've referred to. 2,484 and 2,485. 400. It's paragraph 20. Apologies, line 20. That would be line 12, where it ends.
Advocate Lubala, do you have a copy of the record?
I'm tracking it from my laptop, Chair. I don't have the physical copy.
Okay. Advocate Solomon?
Chair, no, I don't have a copy, and I don't think Mr. Vermeulen does either.
I'll tell you what I'm going to suggest. I see there are paragraphs that this will fall into. Mr. Vermeulen has testified about that on so many occasions. And I'm going to suggest that perhaps they just read out those portions to Mr. Vermeulen before he's questioned about. I've seen this paragraph, yes, at them so many times during his evidence in chief. Can we let's start with 2484, just read that portion that you want to refer to.
Okay, apologies, Chair. It's actually line 25 that I think I should probably start with. No, sorry, it is line 20. Advocate Labala said, conclusion, and here he's quoting from Mr. Vermeulen's witness statement. From the military value perspective, a Type 209 submarine were the most cost-effective of the three submarine product systems on offer. Are you referring to cost price? That's what Advocate Labala asked Mr. Vermeulen. Mr. Vermeulen responded, Chair, in this regard, I'm referring to that slide I produced. If you look at the basic value and the cost to that submarine, I judge that to be the most cost-effective. I know that Softcom, because they were looking at normalized indices, they had other issues to factor in, and I understand that they had to apply a formula. Now, I'm just looking from my, shall I say, simplistic view at the basic value. That's the statement I'm making. My contention is still that the GSC, which met the requirements of the specifications and was 18% cheaper than its nearest rival, was the most cost-effective. But it could be a contentious issue that I'm stating here, but without continuing to the next computation of figures, I think that would stand. If I could now ask the witness and the commissioners to turn to page 45 of the Vermeulen statement bundle. Page 45 of the Vermeulen statement bundle. To confirm, Mr. Vermeulen, the document at page 45 is a request for final offer that was distributed to those bidders selected following the RFI phase. Is that correct?
Yes, that is correct.
Could I ask you to read paragraph 1.1.1 of the RFO?
The request for final offer, hereafter abbreviated RFO, addresses the final part of the offer preparation phase for the acquisition of 4 fully qualified submarines for the South African Navy.
Thank you, Mr. Vermeulen. Based on this paragraph, it is clear that the bidders who responded to the RFO were bidding to supply 4 submarines to the South African Navy as the end user, correct?
That is correct.
During your testimony last week, in particular on Wednesday and Thursday, you provided the acquisition costs quoted by the 4 bidders in the RFO phase. Could you please repeat the acquisition costs you quoted? If you need to refresh your memory, they can be found on your slides or on page 124 of the declassified documents bundle.
The prices are as follows. In the case of the GSC, 4.333 billion. This has been at the South African rate of exchange, quoted in rands. 4.33 billion rands. Fincantieri, Fincantieri is quoted at 5.241 billion rands. I beg your pardon. Fincantieri is quoted at 5.132 billion. DCNI at 5.241 billion. And Celsius Cockham's at 5.567 billion rand.
Mr. Vermeulen, how many submarines were purchased from the German Submarine Consortium?
A total of 3. The 4th one was a costed option, which remained in the scope of supply as an option, and was eventually removed based on a decision by the PCB.
Could you confirm at what stage the decision was made to purchase 3 rather than 4 submarines from the German Submarine Consortium?
I don't know the precise moment, but it definitely occurred before we commenced the negotiation phase.
According to my information, and I have a document to quote from, which I can hand to the Chair if you'd like to see it, that decision was made in June 1998. I can hand up the document if you'd like to have a look.
You can. What is the source of that document?
That is the draft Auditor General's report into the strategic defence procurement packages.
Okay, Solomon.
Chair, just on a point of procedure, obviously we haven't seen this document and I haven't had a chance to discuss the document with Mr. Vermeulen. I don't think this particular document would fall into the controversial category, but any other documents that Mr. Holden wishes to put to this witness, we would require an opportunity of considering those documents, and the witness would then unfortunately have to stand down, so we have an opportunity of taking those documents up with him, because it would be unfair if he's simply asked to comment on documents that he's never seen before. I don't think this particular document will be controversial, but just I don't want to set a precedent where my witnesses are in cross-examination confronted with documents that neither they nor I or the rest of our team have seen. Thank you, Chair, and Commissioner Musi.
Mr. Holden.
I think that's actually a very fair point. I have put together a document bundle. It's only about 10 or 12 pages long. At this stage of proceedings, I don't think it's entirely necessary to hand it out. It may become necessary a little bit later, but I can do so now. And then obviously Mr. Vermeulen could consider those documents if he'd like to.
So you're going to ask him to comment on the document prepared by the Auditor General?
Chair, I've just extracted one fact from that document as the most convenient source of information for the question I just answered. I'm not going to ask for his opinion on that specific fact. I was just, by laying the groundwork in this cross-examination, I was just trying to establish the date at which this decision was made.
Okay, you can do that, but then just bear in mind that I also need to be fair to this witness. He cannot be confronted with documents for the first time now and be asked to comment on them. Just bear that in mind.
I agree with you, Chair. I'm going to come to documents that I'd imagine that Mr. Vermeulen's counsel will probably object to not having read before. Should I distribute these documents now so that he can have a look at them and then consider, or should we carry on?
You can proceed. I'm just saying that as a matter of principle. Let's try and avoid producing documents for the first time during cross-examination and expect the witness to give an answer there and there. If at all the purpose of referring to that document was just to put a date to him, you can do so. But then just bear in mind that, when you deal with other documents, the witness must be given an opportunity of considering those documents.
Chair, may we interpose through your permission? And Commissioner Musi, we are evidence leaders. We led this witness. I suppose our opinion carries weight, albeit this is not our witness. This is a witness for the Commission. We are alive to this document. There's a reason why we didn't put it to the witness, just to rescue the whole process. But we'd like also to have a say, Chair.
Advocate Libala, I apologize. In fact, I should have started with Phoebe because this is your witness. It's an oversight on my part. I apologize.
Thank you, Chair.
Do you want to comment?
Well, we would like this document to be circulated. Its relevancy could be exposing us that we did not do our task, and we did. But we are not here to just debate whether it should be placed before the Commission or not, but it would be more appropriate for it to be circulated before any question are being put to this witness arising from that document.
Can I suggest this? From what I understand, you just want him to confirm a particular date. That's the purpose of that document. I will allow you to do that, but in the meantime, can you make sure that you circulate a copy of that document to the other legal teams?
Yes, we could do that.
Thank you.
Sorry, Chair. Should we hand them to them now or during lunchtime?
I think you can proceed with the question. If you said to me that you would just want him to confirm a particular date contained in that document, I say you can proceed with that question, but then just bear in mind what I said earlier on.
Let me rephrase the question to you so I don't necessarily have to refer to that document. The information at my disposal suggests that the date at which that decision was made was June 1998. As you mentioned in your answer, that would be before the negotiation phase was entered into. Is that correct?
Yes, whilst I can't confirm the exact date, it was certainly, as I said, before the commencement of the negotiation phase, so it sounds correct.
According to my information, the overall evaluation of the Armscor Arms Acquisition Steering Board. Sorry, let me restart that sentence, if you don't mind. So to clarify, Mr. Vermeulen, this decision was made before SOFCOM presented the outcome of the overall evaluations to the Arms Acquisition Steering Board on the 8th of July, 1998.
I can't comment on the accuracy of the date.
Okay. As a matter of interest, are you aware of why, with such a material change to the acquisition, I'm talking about decision to go for 3 submarines?
Mr. Holden, I'm sorry to interrupt again. I'm struggling to follow what you're saying. I think you're talking too softly.
I apologize, Chair. Mr. Vermeulen, as a matter of interest, are you aware of why, with such a material change to the acquisition, and here I'm talking about going for 3 submarines instead of 4, there was not a decision to re-enter the RFO stage and request new information from bidders, which, as you have pointed out, constituted a binding agreement?
I don't know about re-entering an RFO phase. I think your question alludes to the reduction of 4 to 3 submarines. I can only speculate there that it was based on affordability, but I would hesitate to say it resulted in re-entering into an RFO evaluation phase.
As far as I understand, Mr. Vermeulen, the RFO value phase included stipulations as to cost, correct?
Very much so.
I would imagine, as a matter of logic, and I'm sure this should be quite simple to apprehend, that the price for three submarines would be different to the price for 4 submarines.
Very much so.
Which begs the question for me, and I know you maybe weren't part of this decision-making process, but if the RFO constituted a binding commitment in terms of price, and the state agreed to negotiate on the basis of a price quota for 4 submarines, one would imagine that the process would be reopened because the price would be different, and that's a very important part of the RFO process, as you've mentioned.
I think your word is correct when you say one can imagine. I'm not sure what negotiations took place at an upper level. If you recall, there was an IONT that was negotiating the umbrella agreement, and then at a lower level, the supply term. So one could surmise that an agreement was struck and a price was agreed upon, but I wasn't privy to that.
And now we come to, I think you've preempted one of my questions. Are you aware, so when the decision was made to purchase 3 rather than 4 submarines, are you aware of whether an approach was made by any member of the acquisition team to any of the 3 losing bidders in the RFO phase to get a formal and binding quotation as to what it would have cost to purchase 3 rather than 4 submarines?
Not to my knowledge.
As a matter of logic, if they were to have received a new formal and binding quotation, that would have been assessed according to the RFO value system. Is that correct?
Not necessarily. The RFO value system focused on the parameters. Okay. You could be correct in saying it would impact the ILS package. That could be a valid argument. But in terms of revisiting the value system, the same would apply. Remember, it's clear that we only bring in price right at the end. So that value system would apply for 1 submarine in terms of the product itself. It would apply for 1 submarine or 3 or 4. So they wouldn't have scored any different in that respect. In terms of the ILS, it would have had an impact, certainly.
So to clarify, based on what you've just said, you are not personally aware of what the acquisition cost of 3 submarines purchased from Fincantieri, DCN, or Cockham's would have been. Is that correct?
That is correct.
Obviously, I'm not suggesting that you could not make an educated guess on the basis of the existing RFOs. But that's not really my point. My point and my question is this. Is it true you cannot reference a binding price offer from the 3 losing bidders in the RFO evaluation phase to confirm what it would have cost to purchase 3 submarines from Fincantieri, Cockham's, or DCN?
It's correct. It's very hard to extrapolate. You can't simply divide the price by 4 because scale of economy comes into this. Obviously, the more submarines you buy, the price decreases proportionally under normal circumstances. So it would have been difficult to extrapolate and guess at what the losing bidders, what their price would have amounted to in the case of reducing and removing one submarine from its scope of supply.
Mr. Vermeulen, I assume that you're getting at when I answer these questions. But I'm going to put it to you now. Considering this line of questioning, would you consider either retracting or modifying paragraph 6.1 of your witness statement? Please take your time to refresh your memory as to what you said at paragraph 6.1.
I would still stand by the statement, and I'll tell you why. This statement was made based on evaluating the 4 submarines at that stage, and not a reduced amount. Obviously, if you reduce the amount, it could impact the price considerably, and then it would have to be reassessed. Does that answer the question?
It does answer your question, but the thrust of what I'm trying to get at here is you make quite a definitive statement about the cost effectiveness of the 3 submarines that were bought, but you actually don't have a price comparison to compare it against what 3 submarines would have cost from the 3 other suppliers.
But if you will recall, you corrected me earlier on. This was supposed to be 4 product systems containing 4 submarines each. I mentioned 3 submarines here. That was an error on my part. What this statement amounts to, and I think we addressed this earlier on, it should have read, from a military value perspective, the Type 209 submarines were the most cost-effective of the 4 submarine product systems on offer. And at that stage, the 4 submarine product systems consisted of 4 submarines each.
Sorry, Chair, I'm just referring to a document to clarify something very quickly. Okay, thank you for clarifying that, Mr. Vermeulen. I can see why you would want to stand by that statement, but I'd like to draw some inferences from it, if I can. Would it be fair to say that on the basis of the purchase of 3 submarines from each of the 4 suppliers, at this point in time, you couldn't comment as to the cost effectiveness?
That's a fair assessment, yes. I would not have been able to do that because I wouldn't have known the impact on the prices of either of those, of any of those 4 submarine product systems.
Okay, thank you. The reason I asked this question is really it's about a question of competition. And I think you'll apprehend what I'm trying to say here, is that it seems to me that the evaluation process that produced the final results that eventually led to the selection of the preferred bidder was done on the basis of 4 submarines and not 3 submarines. Now, I know the Commission has already indicated that that your opinion may not be valuable in every instance, but would it be fair to say, to your mind at least, as somebody with experience of procurement, that by failing to get a competitive quote or re-entering the RFO phase for 3 submarines rather than 4 submarines, the decision that was made was not competitive and did not take into account the realities of how the contract was going to be negotiated?
I think that's a valid point. At this stage, following the completion of the value system assessment, it was based on a scope of supply of 4 submarines each. So I can understand your sentiments in that regard.
I'm going to put a very, it might not be speculative, but it's quite a broad question. If you were to go back to that phase when it was decided to buy 3 rather than 4 submarines, and it was your decision to make, would you personally have seen the wisdom in asking for another evaluation?
I'm sorry. I think you're asking the witness to speculate now. You're definitely asking the witness to speculate, and I'm not quite sure of what value the answer that is going to give to that question is going to be to the Commission. Maybe let's try and avoid asking the witness to speculate.
Thank you, Chair. I'll try to bear that in mind. Give me 1 second if I can try to rephrase that question. I think the point that I'm trying to establish is that there was no competitive evaluation process at the RFO stage for the purchase of 3 rather than 4 submarines. Can you comment on that?
Yes, the situation was as follows. The basic results were normalized, and those results were then recommended to SOFCON. And that was on the basis of a scope supply having 4 submarines. And that's where the evaluation process, as far as I understand, ended.
Thank you, Mr. Vermeulen. That ends my questions with that line of questioning. Although I would imagine that the Chair appreciates the importance of what Mr. Vermeulen has just said and what I have just asked. Finally, I'd like to turn to an issue that I'm sure that the assorted members of the press would be very keen for me to reference. I'm sure they've been waiting for me to do this. Before I do so, Mr. Vermeulen, please be aware and please take cognizance of the fact that I'm not accusing you of any wrongdoing. Chair, Mr. Vermeulen, can I ask you to turn to page 49 of the witness statement bundle of Mr. Vermeulen? Mr. Vermeulen, to confirm, this is a page in the request for offers that were distributed in February 1998 to those bidders selected as a result of the RFI evaluation process. Is that correct? And you were responsible for compiling this document, correct?
That's correct.
Mr. Vermeulen, could you please read paragraphs 2.15.2 and 2.15.3 into the record, please?
215.2 reads, an offer may be rejected in the event that the buyer has reasonable grounds and is satisfied that an offerer has promised or has caused to be promised bribes, gifts, commissions, or any other consideration whatsoever to any employee of the buyer, government official of South Africa, or an existing contractor of the buyer, or has acted in bad faith in obtaining the contract. 215.3 below reads, any fees paid or due to an offerer's agent who is not a full-time offerer employee must be specified and can be renegotiated by the buyer. The practice of employing agents in South Africa who are not full-time employees of the offerer is discouraged by the buyer.
Thank you, Mr. Vermeulen. If I may ask, and as a matter of interest, as you are part of compiling this document, what you understand by the phrase acted in bad faith in obtaining the contract to mean?
Obviously, it applies to persons who have another agenda, who are possibly, you could refer to enriching themselves, that type of thing.
Thank you. That's a useful clarification for me to work with. Paragraph 2.15.3 stipulates that the offerer must inform the buyer if they have paid fees to an agent of the offerer. Is that correct?
That's correct.
And in this instance, the buyer would be Armscor, correct?
The buyer was Armscor, yes.
Mr. Vermeulen, this is not clear to me, and I was hoping that you could possibly answer this, seeing as you were part of compiling this document. But to what body in Armscor, or to what individual, would the offerer inform if they were employing an agent as contemplated in paragraph 2.1.5?
Normally, if the offerer is going to include, for instance, a local agent, he would have to stipulate that in his offer. He would have to state that he's using a local offer, and normally there would be a price breakdown for the fees for that agent.
Thank you. That's very useful. Mr. Vermeulen, are you personally aware of whether or not the German submarine consortium employs as described in paragraph 2.15.3?
No, I did learn through documentation afterwards that it appears that they had.
I know it might be difficult to recall at this stage, but which agents are you referring to in this instance?
I actually couldn't specify exactly who they were. Unfortunately, I don't have those details.
Mr. Vermeulen, during the evaluation process and thereafter, were you ever personally approached, formally or informally, by any individual or entity that would fit the definition of an agent as described in paragraph 2.15.3?
No. Are we talking about during the negotiation phase?
I would like to restrict this to the RFO phase. I know the chair has asked me to be specific. I'd like to ask you about the negotiation phase, but I'll phrase that in a different question.
Okay, during the RFO phase, when we're evaluating offers, especially in a competitive bid of this nature, I would not entertain discussing anything of any nature with a contractor. It's mandatory that I work through a procurement secretariat, and that works both ways. If I have to solicit more information, if there's unclarity with respect to an offer, I would work through the procurement secretariat. And likewise, whatever information we would glean from that, we would pass on to all the bidders so that they all have the same information. If any contractor or offerer approached me directly, I would immediately refer them to the procurement secretariat.
Thank you. I think just to clarify on that point, I'm comforted by the fact that you would have reported that. I'm pretty sure that you would have. The question that I asked, though, was there ever an attempt to approach you that you are aware of?
No, I'm not aware of any attempt.
Mr. Vermeulen, are you familiar with the name Commander Jeremy Mathers?
Yes, I am.
Mr. Vermeulen, have you in the past had any formal or informal contact with Commander Jeremy Mathers?
Are we talking about before the SDPPs?
Before the SDPPs, and if you wouldn't mind doing I know that I don't want to preempt a question I was going to ask you, and the RFI phase.
Very much so before the SDPPs. If I remember correctly, Commodore Howell was Director of Fleet Logistics. It was one of the posts he occupied. So he dealt at some length with our office in Simonstown in that portfolio. Certainly not during the RFO evaluation process. I didn't deal with him. If I remember correctly, he would have been out of the Navy at that stage. Then I definitely wouldn't have dealt with him. Sorry, did I say Howell? Commodore Mathers. Yeah. Shall I repeat all that? With respect to Commodore Mathers, just let me start again for clarity. I definitely dealt with Commodore Mathers before the RFO evaluation, before the SDPPs. During the SDPPs, during the evaluation period, I don't recall dealing with him. I certainly don't. And during the negotiation phase, I would have dealt directly with the GSC. I know that I met up with Commodore Howell after the contract had been placed, once again, Commodore Mathis, during the course of the production phase, he did come through to Germany, and he did visit Captain Reed, the project officer, in our office in Kiel, and I also spoke to him then. But that was after the contract had been placed. And that was when I also learned that he was, in fact, he had a role to play with the GSC at that stage.
I appreciate that this was a long time ago, Mr. Vermeulen, but can you recall what official position Commander Jeremy Mathis held at the time of the initiation of Project Wills?
I couldn't say for certain exactly what he was involved with at that stage.
Chair, this is the point at which I would have asked the witness to quote from documents in my document bundle. Maybe this would be an appropriate time to distribute them and let them assess them.
Chair, may we interpose? I suppose that would be an appropriate time for lunch adjournment. We are being shortchanged. We're posing ourselves a question, why? We're not being provided with this important, seeming to be document. Just to us, or I see that it's been provided to us, Chair. I'm indebted to Mr. Holden, Chair. Thank you, Mr. Holden.
You know, I'm seeing this document for the first time, and I say it's already 10 to 1. Can perhaps Mr. Holden go through them with us very quickly and tell us what documents are these that he has just distributed?
In this section of the cross-examination, I would like to quote from Annexure PH3. That is an extract from a Ferrostyle compliance investigation, and that was conducted by the U.S. law firm Debevoise in Plimpton on the 13th of April 2001. That appears at page 5 and 6 in the document bundle.
Chairperson and Commissioner Musi, just to assist, the important team of evidence leaders is almost complete. Some of our colleagues who have a great interest, probably more than us, in this testimony are present. So would request that we should adjourn and copies should be made available to them. It's a coincidence today, Mr. Holden, that almost the part of the large percentage of the evidence leaders are here to hear testimony. So it would be appropriate if there are additional documents that you have other than this. I would request you to make copies because they would also like to make note of what you say, and when you refer, I'm certain that they have a keen interest. I assure you that some of them are going to lead evidence on this particular aspect when you go to other terms of reference. And of significance is I see that Ms. Sneeman is next to you. She knows how important distribution of this documentation is to colleagues or those who have an interest in leading evidence or cross-examining when copies are being made. So I'm going to request that if there are additional copies through the commission, that you'd like to distribute, you should do it during lunch adjournment. And not only to myself, Kane SC, and Solomon SC. I've got colleagues behind me who have an interest in this.
Thank you, Advocate. While I understand that, can you just continue, try to explain to us before we adjourn what are these documents that we've just distributed?
Fair enough. I'd just like to make the point to Advocate Labala as well that these documents that I'm quoting from in this instance were actually submitted as annexures to mine and Andrew Feinstein's joint submission to the Commission. That's why I was hoping that maybe the evidence leaders would have knowledge of those documents. The second document I'd like to refer to is Annexure PH5, and that's at pages 8 to 9. And that is an extract from the draft Auditor General's report into the SDPP, which I'm sure the Commissioner is aware I've dealt with in quite substantial detail in my submissions to the Commission so far.
I think maybe this might be an appropriate moment to adjourn. We'll come back at 2 o'clock. Thank you.
Ngizokrosa ngefoni isendlebeni. My headphones angazephi manje. Usondela nyana emuva. Just la.